The designated hour having arrived, I call to order this regular meeting of Ansel Glink's Quorum Forum podcast, the podcast. Local governments need to do business in the chair. It's me, Daniel J. Bolin, and on the agenda today, it's new developments in planning case law. But first, let's take the roll. Behind the glass, Engineer Rick is present, but Rick, who else do you have back there? Looks like our friends Lacey Rains and Jeff Marino from the American Planning Association, Illinois State Section.
Hey, Lacey, how's it going?
Good. But have you seen Dan? He's looking pretty, down.
Dan's looking pretty, down. I've got just the thing to cheer him up.
You do? What?
Yeah, the APA-IL-ISS SPC.
The SP what now?
The APA-ISS SPC. It's the American Planning Association Illinois State Section Spring Planning Conference. They're going to have sessions on sustainability, professional development, law, ethics. It's awesome.
I don't know, Jeff. A conference like that must cost $600.
No, less.
$300?
Less.
$150.
Try 70.
Shut the front door.
It's a virtual conference, April 24th and 25th. If you're interested, you should sign up fast because space is limited.
How do I sign up?
Go to ilapa.org and go to conferences. It's super easy.
Okay, I can't hear you in there, but you all are pressing a sign to the glass that says go to ilapa.org, go to conferences, and use coupon code FORUMFANS, all one word, for $5 off registration for the APA Illinois State Section Conference, April 24th and 25th. That's coupon code FORUMFANS just for Quorum Forum listeners for $5 off. Register today. Okay, that was weird, but we have a quorum. Recently, Ansel Glink attorneys Megan Mack, Aaron Monforti, and Katie Nagy participated in the planning webcast series hosted by the Ohio chapter of the American Planning Association and presented by the Illinois chapter. It was new developments in planning case law. The session covered key cases impacting local governments and planning professionals ranging from regulatory takings and impact fees to group homes, zoning regulations, and homelessness. And we are pleased to share this webcast with you today on Ansel Glink's Quorum Forum podcast. Now, it was a December webcast, but it still holds up. But just pretend that the upcoming holidays they are mentioning refer to St. Patrick's Day rather than Christmas and New Year's. Without further ado, Engineer Rick, roll it.
Hello, everyone, and welcome to the webcast. My name is Christine Dorsey Davis. I'm the Executive Director of the Ohio chapter of the American Planning Association, and I am your webcast moderator. Today, we will hear the long-awaited new developments in planning case law for 2024. For questions related to the presentation, just type those in the Q&A box, and we will get to them at the end of the presentation during the Q&A. Coming up on your screen is a list of our 2024 consortium members, which are built on APA chapters and divisions. So thanks to all the participating consortium members for making these webcasts possible and free to members. Today, we're hosted by the Illinois chapter of APA. So thanks to you for joining us and for bringing this session. Up on your screen is a list of our upcoming sessions. I can't believe it. I'm booked through March, I believe. We're moving quickly here in 2025 already. You can register for these and all of our upcoming sessions by heading over to our website, ohioplanning.org/planningwebcast. Today's session has been approved for 1.5 CM credits and one of those law credits. So to log your credits, head over to planning.org. Log into your My APA account, and from there you can search by today's title or event number, both of which can be found on our website. Again, ohioplanning.org/planningwebcast. If you're on social media, be sure to like us on Facebook. That's where I post any important date or time changes or when new sessions are available for you to register for, and of course, the weekly What's on Tap. We record all of our sessions and post them to our YouTube channel. So head over to YouTube and type in Planning Webcast, and we will pop up along with our well over 500 session recordings, all available to you for free. So be sure to subscribe to our channel so you get notified when a new recording has been posted. New this year, we have a subscribe option. So just take a picture of that QR code there, and you can sign up to receive one email a month from me, and it will include all of our upcoming sessions and any other important items that you might need to know as you're getting your AICP-CM credits all logged. So be sure to subscribe to our newsletter mailing list so that you can receive information once a month from me. So that's the end of my housekeeping items. Again, if you have questions, type them in that chat or in the Q&A box, and we'll get to those at the end. With that, I'm turning it over to you, Megan Mack, to kick things off.
Thank you. Hi, I'm Megan Mack. I'm joined today by my colleagues Erin Monforti and Katie Nagy. We're all attorneys with Ansel Glink. Thank you, Christine and APA, for asking us back. I think it was about the same time last year that Erin, Katie, and I presented on land use and planning case law updates, and we were super flattered to be asked to do it again today. If you haven't heard of Ansel Glink, we're one of the oldest municipal law firms in Illinois. Our main firm headquarters is in Chicago, but we are growing fast, and we have 6 additional locations throughout the state. Our firm was founded on the theory that units of local government deserve the same quality representation as private sector businesses at rates that local government can afford. So in that capacity, we serve as counsel for many municipal corporations, including larger cities to smaller villages, to park districts, library districts, school districts, and townships. Our firm focuses in all areas of law of local government that local governments need, which includes litigation, election law, labor and employment, workers' compensation, and land use. And when we aren't practicing local government law, we're often presenting on it, just as we are here today for you. And so with that, I want to briefly mention to you some of our free resources. If you click on our website, anselglink.com, you'll see in the upper right-hand corner, there's a tag that says blogs. We publish 2 blogs that you can access, and then you can sign up for email alerts. And the one blog is called Workplace Report. It focuses more on labor and employment issues. The second is called Municipal Minute. All 3 of your speakers today, we contribute to Municipal Minute. It's a great place to check out case law updates on all issues related to local government. We also have on our website a resource center where you can find many of our publications. Even though we are Illinois attorneys, I think you'll find some great resources to you as planners that include, one specifically includes a presentation to assist planners on studying for the AICP. It's called the APA CMS Bar Exam. It was actually presented at a bar right before the AICP. And there's another publication that I think you'll enjoy that focuses specifically on land use, and it's called In the Zone. We try and send it out quarterly, but at least a couple times a year. Lastly, we have a podcast, and like all local government things, is called Quorum Forum, Quorum. Today's presentation, along with all other presentations given by members of our firm, are available by listening to Quorum Forum. You can find Quorum Forum on Apple Podcasts, Spotify, Google it. It'll pop up. So many ways to listen. It's all free. I promise that's the end of my shameless Ansel Glink plugs. As we mentioned earlier, I'm Megan Mack. I've been with Ansel Glink since 2016. Prior to that, I served as an assistant state's attorney for 10 years. Prior to going to law school, I worked in transportation and environmental planning. I'm happy to admit to you that I've always had a career in local government. At Ansel Glink, I mainly represent municipalities and park districts. In addition to practicing what we refer to as corporate law, I focus in municipal litigation, land use, and zoning. I live in the northwest suburbs where I have 4 kids and a lot of shopping still to do. So with that, I'm going to turn this over to introduce you to my colleague, Erin Monforti.
Hi, everyone. As Megan said, my name is Erin Monforti. I'm also an attorney at Ansel Glink in Chicago. I'm really glad to be here with all of you today. I think that Christine was giving us some information about the attendance numbers this afternoon, and I'm so pleased that even so close to the holidays, everyone has made some time to get some SAM credits. So it's good to be here with all of you. In my practice, as Megan said, our firm represents all different units of local government in Illinois. I primarily represent municipalities, library districts, and park districts. And I do a lot of land use and economic development work. I have some prior experience working with some local governments in Illinois in-house in economic development and with their corporation counsel's offices. And then most excitingly, recently, for better or worse, we've had a lot of land use litigation popping up at our firm. And so I've been helping a lot with those cases recently, which we'll be touching on a lot of issues today. And some of them come up in litigation, some of them come up on the corporate side, as Megan inferred earlier. So we're really excited to be here and presenting, and we'll take your questions at the end. And so I'll turn it over to Katie to introduce herself.
Hello, everyone. I am an associate at Ansel Glink in the Chicago office. I am a Michigan State University alum, and then I went to University of Illinois, Urbana-Champaign for law school. So definitely a Big Ten girl at heart. I worked for 2 municipalities in-house during my time in law school, which then led me, thankfully, to Ansel Glink. I do general corporate work for the firm and our clients with a focus on real estate work such as property tax exemptions and assessment appeals. And I'm thrilled to be back talking with you all again. So thank you for having us.
So, of course, we wouldn't be lawyers if we didn't start this presentation off with a disclaimer. We want to make sure you know today that our presentation is not meant to be legal advice, nor should it take the place of having meaningful discussions with your own attorney. We are happy to present to you today on 21 cases. We understand we have a fairly large crowd, so unlike last year where we were able to field questions as we went, this time we're going to hold off. Please don't let that from discouraging you from submitting questions in the chat. We're going to try and tackle as many as we can at the end of this. We have 90 minutes and we don't believe we're going to talk that long. So we hope to get to all of your questions in advance. If we get cut off, you get cut off, or we get cut off, and you have a question you really want to get to us, at the last slide will have our emails on that. You're always welcome to email us. We're happy to follow up with you after this presentation. So with that, take it away, Katie.
Thank you, Megan. The first case I'm going to be talking about with you all is Mojave Pistachios versus Superior Court of Orange County. The California Appellate Court in this case dismissed a challenge to a newly adopted Sustainable Groundwater Management Act. Mojave Pistachios LLC owns about 1,600 acres in the Mojave Desert, where it operates a pistachio orchard that it irrigates with groundwater pumped from the underlying water basin. In 2014, California legislature enacted the Sustainable Groundwater Management Act, which requires the creation of groundwater sustainability plans to manage high-priority groundwater basins, just like the one that Mojave Pistachios was pulling water from. Under this authority, a local agency determined that, subject to certain exceptions, all groundwater extraction in the basin would be subject to a basin replenishment fee starting in 2021. Mojave Pistachios refused to pay the fee and attacked the agency's authority to implement the replenishment fee. Amongst other arguments, Mojave contended that the replenishment fee was an unconstitutional taking because it deprived Mojave of all economically beneficial use of its water rights and pistachio trees. Mojave argued that if the replenishment fee is enforced, it would render the farming operation economically unviable because the cost of water would actually exceed the gross revenue. The court noted that it was not clear whether Mojave had a constitutional right to be fairly compensated in this instance because groundwater belongs to the state, not any person or entity. And it was not clear that a right to groundwater means a right to free groundwater. The court weighed the interest of the farmers subject to the new fee. In some instances, the fee imposed millions of dollars in fees annually, for what historically had been free, and the agency's Herculean task of creating a groundwater sustainability plan. Ultimately, though, the court dismissed the case on procedural grounds rather than substantive, as the court upheld California's pay first, litigate later rule. And this is exactly what it sounds like: pay first, litigate later. It requires a litigant to actually pay the imposed fee before they can commence a court action to challenge the collection of the fee that they paid.
Great. And on the subject of takings and impact fees, this is a huge case that we've been talking about since it was issued earlier this year. And part of that is because it's a U.S. Supreme Court case. This is Sheets versus the County of El Dorado, California. And in Sheets, the Supreme Court held that legislatively enacted impact fees are not exempt from the takings analysis required by Nolan and Bolin. So if you took any planning law classes while you were in school, Nolan and Bolin are two cases addressing impact fees in the context of negotiated fees for development. So if you're putting it, you propose a development and the municipality comes back to, propose a fee or some other condition for developing land, it has to be roughly proportional to the development, and it has to share a common nexus with the development. So we'll get into that a little bit more, but that's to prime your memory for any planning law cases that you took in the past. So the owners of property in the center of El Dorado County, California, they owned property that was zoned in low density residential, the low density residential zoning district. And they applied for a building permit to build a small prefabricated house. So the cost of this development was relatively low. But as a condition to the permit, the county required the owners to pay a traffic impact fee upwards of $23,000, as required by the county's general plan rate schedule. The owners paid the fee under protest and received the permit, but then sued the county in state court. The owners claimed that the county's condition of a building permit on the payment of a traffic impact fee constituted an unlawful exaction in violation of the takings clause of the Fifth Amendment. The owners relied heavily on the Supreme Court's rulings in Nolan versus California Coastal Commission and Bolin versus City of Tigard. Nolan and Bolin established that the government may condition approval of a land use permit on the landowner's agreement to dedicate a portion of his property to the public, so long as there is an essential nexus and rough proportionality between the property that the government demands and the social costs of the landowner's proposal. So this is like a rational basis test. Is there a rational basis for the city to, or in this case, the county, to impose an exaction on the developer? There's a third Supreme Court case dealing with exactions called Coons, which extended the Nolan and Bolin test to so-called monetary exactions. So it used to be for the dedication of land. Coons extended it to say, if you're requiring the payment of a fee, that counts as property as well. And so there must be, again, an essential nexus and rough proportionality between the impact of a development and the fee that's demanded. The owners in this case claim that the county's traffic impact mitigation fee was not calculated based on any individualized determination as to the nature and extent of traffic impacts caused by the development on state and local roads. Instead, the fee was established by a formula that was based on the location of the project and the type of project. So it was based on where it was located within the county and whether it was a residential, commercial, or industrial project. And they said that was insufficient to show that there was a rough proportionality between their use, the small prefabricated home, and the large impact fee that was demanded. This case made its way to the U.S. Supreme Court, and the court recognized that the government's authority to regulate land use and condition a building permit to further a legitimate police power purpose. However, the court held that legislatively imposed fees are not exempt from the takings clause, and they could violate the Fifth Amendment if they don't have an essential nexus to the government's land use interest and a rough proportionality to the development's impact on that interest. The Supreme Court noted that the text of the takings clause does not distinguish between legislative and administrative permit conditions, and either could constitute an unconstitutional condition on land use permits. The Supreme Court did not determine the validity of the county's impact fee on this case or the degree of specificity required when tailoring an impact fee, and instead sent the case back down to state court for further proceedings. So again, impact fees are always something to consider when you're conditioning land use approvals on a fee or the donation of land. You have to make sure that the donation is roughly proportional to the impact of the development, and then that the donation has some kind of logical connection to the development being proposed. And in Nolan, Dolan, and Kuntz, we've seen issues related to, an easement for coastal access, bike paths, and in this case, permit fees for traffic impact studies. So I really recommend taking a closer look at Sheets. We've got a great case on a great post on Municipal Minute about it. And we're sure to see more takings and impact fee cases in the coming years.
I'm going to talk about a case out of the Minnesota Supreme Court about attorney's fees for land use litigation. The case is called Minnesota v. Schaefer. Here, the court considered whether attorney's fees awarded under Minnesota statute that entitles the landowners to additional award of reasonable attorney's fees is capped at the amount set when there's a contingent fee agreement between the landowner and the landowner's attorney. So when a landowner in an eminent domain proceeding is awarded just compensation in an amount of over 40%, greater than what was originally offered by the government entity when they're condemning their property, the landowner is then entitled to an additional award of reasonable attorney's fees. So in this case, the Minnesota Department of Transportation condemned a portion of property and then offered the landowner $43,000 in compensation. When the owner refused the offer of $43,000 for his property, the Minnesota DOT seized the property under the state's quick take procedure. So the quick take is a process where the petitioner, which in this case was Minnesota DOT, 90 days prior to the date of taking possession, they notify the owner of their intent to possess by certified mail. Then they have to either pay the owner or deposit with the court an amount equal to their approved appraisal value. The amounts deposited are then held with the court, and then the court pays them out at their discretion. So the homeowner appealed this $43,000, or the property owner, and the court awarded the landowner actually $92,000 in compensation after their hearing for a valuation dispute. Because that compensation award was 40% greater than what the Department of Transportation originally offered, the landowner by statute was entitled to attorney's fees. On appeal of this offer, the DOT then refused to pay the fees after the district court used the lodestar formula and paid the landowner $63,228 for their attorney fees, arguing that the word reasonable means the amount owed in the pre-existing contingent fee arrangement between the landowner and their attorney. So prior to this going up on the valuation dispute, there had been an arrangement between the landowner and its attorney that the contingent fee would be $16,000. Because this award came back that the property was worth $92 instead of $43, the lodestar formula then kicks in. The lodestar formula is a method for calculating attorney's fees by multiplying the reasonable number of hours worked on a case by the reasonable hourly rate. The Court of Appeals upheld that reasonable does not expressly limit the amount based on an existing agreement, and the lodestar formula itself is a reasonable means to calculate fees. On appeal, the Supreme Court of Minnesota held that the district court's award was proper because the consideration of the pre-existing fee arrangement is only one of the factors that considered under the lodestar framework, and it was otherwise reasonable. So that was a huge win for the attorneys because their fees went from $16,000 to $63,000.
Okay, I really enjoy this case. I think it demonstrates how closely zoning regulations should be watched when they're being enacted, as often there will be loopholes that businesses will take advantage of. So in 1995, New York City enacted zoning regulations targeting adult establishments for the first time by prohibiting adult stores within a certain radius of churches and schools. Many adult establishments complied with these zoning regulations, through a loophole that exempted businesses from compliance with the zoning regulations if they limited their adult merchandise to less than 40% of the total store floor area. According to the New York City Department of City Planning, shockingly or probably not shockingly, many establishments abused or took full advantage of this 60-40 rule. So they would purchase inexpensive, outdated, or just repetitive non-adult materials. So that way they could achieve mathematical compliance of the 60-40 rule and evade enforcement of the New York City zoning regulations. Aware of this loophole, New York City revised the ordinances to close the loophole. In 689 Eatery Corporation versus City of New York, 19 corporations that provided adult entertainment, including adult clubs and adult bookstores, challenged the constitutionality of the New York City Amendment, which again closed the loophole that they were taking advantage of. On appeal, the plaintiffs alleged that they were deprived of their First and 14th Amendment rights, and they sought permanent injunctive relief against the New York City 2001 Amendment closing the loophole. The principal argument was that if the amendment was enforced, it would dramatically reduce adult-oriented expression in violation of the free expression and equal protection clauses. The New York Southern District Court affirmed the findings of the lower court. First, the court determined that the 2001 amendment was an appropriate time, place, manner restriction because it did not impose an all-out ban on protected adult speech. Rather, the amendments regulated where the speech can be delivered, but not whether it can be delivered. Second, the court found that because the amendment was directed at the secondary effects of speech instead of the speech itself, the amendment was considered content neutral rather than content based, and it triggers intermediate scrutiny by the courts. In this instance, New York City provided evidence that a business entirely devoted to sexually explicit materials would be associated with secondary negative effects in the community. The court applied intermediate scrutiny and asked whether the ordinance serves a substantial government interest and allows for reasonable alternative avenues of communication. The court determined that the city had provided substantial and credible evidence to support that it had a substantial governmental interest in regulating adult businesses. And they argued that the adult businesses had numerous available lots in the city that they could operate out of. The court noted that the business owners' arguments concerning inconvenience or inaccessibility of the alternative sites was irrelevant because the city had met its burden to show in a quantitative manner that there were ample sites available for relocation of the adult uses. So this case is a good example of, like I said previously, the loopholes that can often arise in zoning regulations, and that corporations will, or not just corporations, but that entities will often take advantage of those loopholes, and the authority to impose content neutral time, place, manner restrictions on uses that cause secondary negative effects in communities.
Okay, my next case is Erickson versus Knoxtown Even Farm. This is an appellate court case out of Illinois. So in Erickson, an Illinois appellate court ruled in favor of a county and a developer in a zoning dispute brought by residents and neighbors to challenge the approval of a wind energy farm project in the county. And so just for some background context for our folks who aren't Illinois residents and planners, wind farms and solar fields have become a huge hot topic in planning in Illinois due to some recent legislative changes to the Illinois Counties Code. And so we welcome questions across the board because this issue we think is going to become more and more serious since the perceived negative effects of wind and solar uses are pretty serious, and they impact an interesting area of uses, including agricultural and industrial uses. So in this case, a wind farm developer filed an application with the county for approval of a conditional use permit and variation to allow the construction and operation of a wind energy farm. The county approved the variation and recommended that the county board approve the conditional use permit. After the county board approved the permit, a group of residents filed a lawsuit against the county and the wind farm developer, asking the court to overturn the approval as irrational. The residents claimed that the approvals violated their procedural due process rights, were arbitrary and capricious, and that the ZBA had failed to issue findings of fact, meaning that the application did not meet the variation standards set out in the county's zoning ordinance. On appeal, the appellate court upheld the rulings of the trial court in favor of the county and the developer. First, the appellate court held that the residents had actual notice of the ZBA hearing and a meaningful opportunity to be heard at that hearing, and therefore they had no procedural due process claim that they weren't afforded those key due process rights. The fact that the notice of the hearing came shortly before the hearing did not violate their procedural due process rights because they had time to prepare and were able to cross-examine the developer's witnesses. So that's usually a great argument on a procedural due process claim, is that if the person who's claiming they didn't have their rights validated, they weren't able, the notice and hearing process was unfair. If they attended the hearing and were able to participate, that usually cuts against an argument that the procedures were unfair. Second, the court rejected the arguments that the approvals were arbitrary and capricious under a test that's active in the Illinois courts for substantive due process called the LaSalle factors test. So the LaSalle test is used to determine whether a municipal ordinance is valid, and the following factors are taken into account. Now, even though this is the test used by Illinois courts, it's a pretty universal test of whether a zoning regulation meets the rational basis standard for zoning decisions. So the factors of this test include the existing uses and zoning of nearby property values, the health, safety, and general welfare of the public, and the impact of the development on those factors, the relative gain to the public compared to the hardship of the property owner for a variation, the suitability of the project for the surrounding area, the duration of vacancy for the project without the land use approval, the community need for the proposed use, and the care of community that is exemplified through past zoning and land use regulations. The court in Erickson held that the residents failed to specifically argue these factors or anything related to the rational basis of the project to overcome the presumption of validity that's attached to local government's zoning decisions. Third, the court found that the ZBA did issue findings of fact after it granted the variation, and they supplemented these findings after the lawsuit was filed. The court held that because the findings were made before the court considered the merits of the lawsuit, there was no prejudice to the residents. Fourth, the court rejected the residents' argument that the county was required to provide them with due process before it issued building permits for the wind farm. And finally, the court upheld the approval of the variation, holding that there was sufficient evidence in the record that the application met the variation standards, including undue hardship. So I think, like I said, we'll see more and more of these cases as solar and wind developments are continually pushed for. I know that in Illinois, there are some rebate programs, and I think the federal EPA has some as well. So there's a huge incentive for these developments right now. And managing zoning approvals and building permits will undoubtedly cause some neighbor uproar, as we saw in this case.
So this is our second Supreme Court case that we're discussing today. The last one Aaron talked about was the Sheets case. This is one that I'm not sure if we talked about last year because we were waiting for it to go up to the Supreme Court to get a decision. So it's the City of Grants Pass versus Johnson. And here, the Supreme Court issued its opinion challenging several ordinances that prohibited sleeping and camping on public property. The City of Grants Pass had ordinances that prohibit 1, sleeping on public sidewalks and streets, 2, it prohibited camping on public property, and 3, prohibited camping and overnight parking in city parks. The violators of these ordinances were subject to penalties that are implemented on a gradual scale. So initial violators maybe would be issued a fine, repeat offenders would be banned from parks, and then eventually you could be charged with criminal trespass and possibly jailed for a short period of time. Just in case you're wondering, the City of Grants Pass is located in southwestern Oregon, and its population is 38,000, and 600 of that 38,000 are homeless. So 2 homeless individuals brought this case against the city, challenging the ordinances as unconstitutional under the 8th Amendment, which prohibits cruel and unusual punishment for criminal offenses. And the plaintiffs argued that the ordinances effectively punish them for their status as homeless individuals and that this criminal classification was unconstitutional. So the Supreme Court reversed the rulings of the lower court and found in favor of the plaintiffs and held that the city's ordinances were constitutional, that both the majority and dissenting opinions, and this is a really long opinion, I feel like it's like over 80 pages, discussed that the acute homeless crisis affecting individuals in the United States, as well as difficulties local governments have face in responding to related public health and safety issues that impact homeless individuals and the general public. But the court held that the enforcement of generally applicable laws regulating camping on public property does not in itself constitute cruel and unusual punishment, which is prohibited by the 8th Amendment. The court also found that local governments had been paralyzed from making policy decisions to address homelessness in their communities after the Ninth Circuit had issued an opinion in 2019, finding that the 8th Amendment barred specifically Boise, Idaho, from enforcing its public camping ban against homeless individuals who did not have access to alternative shelter. So as a result of this, local governments are now considering adopting ordinances to address the use of public property, but in doing so, you should consult with your attorneys to discuss the applicability of this case as to other state laws and regulations. There are other protections in place for homeless individuals. For example, in Illinois, the Bill of Rights for the Homeless Act prohibits discrimination on the basis of housing status. It also establishes, among others, the following rights for individuals experiencing homelessness, such as the right to use and move freely in public spaces, the right to equal treatment, and the right to the reasonable expectation of privacy.
Okay, another U.S. Supreme Court case in DeVilliers versus Texas. The United States Supreme Court vacated a Fifth Circuit Court of Appeals decision and ruled that the impacted property owners had a cause of action to seek just compensation against the state of Texas. In this case, Texas undertook several projects to facilitate the use of a portion of the interstate highway as a flood evacuation route. It installed a barrier along the highway median to act as a dam in order to prevent stormwater from traveling south of the road. The DeVilliers family owns a ranch on the north side of this median dam. During a hurricane, the barrier performed as intended and kept water off the south side of the highway, but it ended up submerging the DeVilliers property on the north side. DeVilliers argued that this constituted an unconstitutional taking of his property and that he was entitled to just compensation under the United States and Texas constitutions. Texas essentially argued that while the takings clause requires the government to pay for land that it takes or makes unusable in this case as well, Congress has never passed a statute that commands Texas to obey the Fifth Amendment. Somewhat surprisingly, the Fifth Circuit Court of Appeals agreed with Texas's argument. It held that the Fifth Amendment takings clause, as applied to the state of Texas, did not provide a right of action for takings claims against the state. On appeal at the United States Supreme Court, the Supreme Court unanimously disagreed with the Fifth Circuit Court of Appeal. So that gives some indication on how it was somewhat clear to them that this case should have gone the other way. So the Supreme Court noted that Texas state law provides an inverse condemnation cause of action. That essentially means that property owners can seek damages from a government entity when the government entity takes property without using the eminent domain procedures. Therefore, property owners could use the inverse condemnation cause of action to bring takings claims under both the United States and the Texas Constitution. However, I just want to note that the Supreme Court did not address the specific issue of whether the takings clause itself creates a private cause of action for damages, as I noted it looked to Texas state law, which provided the inverse condemnation cause of action. So that is important to note that they did not decide the initial issue presented.
Yeah, and Katie's point to the unanimous decision of the court is something that I think a lot of attendees might strike attendees, and that's true. And Megan mentioned for the last case that it was a really long opinion on Grants Pass, and what we're seeing is the opinions are getting longer because it's almost always a split court. So when there's a majority opinion, a concurring opinion, and a dissenting opinion, all of those opinions could be 30 pages or longer. So the de Villiers case is a rare one in this term of the Supreme Court because it was unanimous, and that just goes to show that the takings clause in the Fifth Amendment, those rights have been imputed to people via the states in the Fifth and 14th Amendments. And I'm surprised that it went up to the Supreme Court on kind of what I would say is not a simple issue, but one that seemed to have an obvious answer from the start. So next, I'm going to be talking about hunting on public property. So this is Brenczewski versus the Forest Preserve of Will County. So in this case, a hunter in Illinois filed a lawsuit against a forest preserve district alleging a violation of his constitutional rights, as well as tortious, that's quite a word, a tort-based claim for interference with his business expectancy. So in 1996, property owners gave permission to a hunter to use their property to hunt on, granting him a private license that was later memorialized in writing. So just a quick reminder for listeners, a license is a temporary contract right to access property, whereas an easement is a property right. So those are two distinct things. Typically, it's easier to revoke a license. It's not quite so easy to revoke an easement, but just to situate us here. So in April 2020, district employees, the Forest Preserve District, purchased a parcel of land that effectively blocked the hunter's access to what was previously granted to him by the former owners. After the purchase, the landowners sent the hunter a written revocation of the license to use the property for hunting. The hunter then filed a lawsuit alleging that the Forest Preserve District violated his constitutional rights and interfered with his business interest, with the business interest between the hunter and the private property owners. The trial court dismissed the case, finding that the permission to hunt was not a right protected by the Constitution. On appeal, the court also dismissed, but on very different grounds. The appellate court held that there was no constitutional violation because there was no government actor involved. The license to hunt was initially granted by a private property owner, and then they sold their property to the government. This did not imply that the government violated any constitutional rights when the license was revoked by the private property owner. Finally, on the hunter's business expectancy claim, the court held that because the permission to hunt was for a recreational, non-commercial purpose and was provided at no charge to the hunter, there was no business expectation or relationship that would otherwise have been impaired by the Forest Preserve's purchase of the property. So this is an interesting case dealing with the difference between license rights, which are contract rights, and what kind of activity is protected by the constitutional rights, including the Second Amendment and other rights that the hunter had claimed protected his right to access the land.
So this case is on municipal firearm restrictions. The Pennsylvania Supreme Court recently held that an ordinance banning a shooting range on residential property did not violate the Second Amendment. A resident who lawfully owned registered firearms had built his own personal outdoor shooting range on his property. Not surprisingly, the neighboring property owner made several reports to the police about the noise and possible safety concerns. After all the reports, the police investigated and determined that the resident appeared to have a safe backstop in the shooting area and the activities were not otherwise prohibited by law. And this went on for, I want to say, almost 10 years. The Township Board of Supervisors enacted an ordinance prohibiting the discharge of firearms at an outdoor residential shooting range in response to the complaints from this neighbor and other surrounding residents. The resident continued to use the shooting range and filed for a zoning permit application to attempt to comply with the ordinance. The permit was denied, and the resident then appealed to the county court, which held in his favor. On appeal, the resident claimed that the ordinance had a chilling effect on his right to bear arms and that it was unconstitutional. The township, in response, argued that the discharge ordinance did not interfere with the resident's ability to own firearms, but it simply prohibited him from discharging them wherever he wanted. Further, the township argued that the Second Amendment exclusively protects the right to possess firearms, but plainly fails to protect a constitutional right to train with firearms on residential property. And so the court undertook a history and tradition test and found that most firearm regulations function exactly as the township's ordinance. And traditionally, the ordinances function to promote safety and prevent nuisance. So while the resident plainly has the right to bear arms, the township met its burden to justify the discharge ordinance, and it was found proper for traditional purposes.
Okay, so I believe we actually received a question about this case, so I will get to that after I go through the summary. And this is the Illinois Supreme Court case Olive versus City of Chicago. In this case, a bicyclist sustained permanent injuries while riding his bike at an intersection near a Divvy bike share station where he struck a pothole and fell off. For those of you who may not know, Divvy bikes are sort of rental bikes that are just sitting on sidewalks throughout the city of Chicago. I'm not aware of their national presence, but at least in Chicago. And you connect to your phone, you can rent it for your ride, and then you put it in sort of a docking station at the other location you ended up at. So the biker was riding his bike at an intersection near a Divvy bike share station, and he struck a pothole and fell off. The injured biker filed suit against the city of Chicago for negligence, alleging that because the city maintained the Divvy station at the intersection where the accident had occurred, that the roadway was intended to be used by bicyclists and that the city had a duty of reasonable care for these intended users. On appeal at the Illinois Supreme Court, the court reversed the first district's holding in favor of Olive. The Illinois Supreme Court found that the city did not intend for the plaintiff to be riding a bicycle at the location in question. The court noted that there were no bike lanes or other markings on the roadway to show that the city intended bicyclists to use the roadway. The court did note that the Divvy bike rental station was a factor to consider as it was close to the location in question where Olive was injured. However, the presence of the bike stations did not alter the established precedent, which is to look at the affirmative physical manifestations of the location in question. Like I mentioned, bike lanes, markings on the roadway, something to show that the city did intend for bicyclists to be riding their bike in that area. So while tort immunity laws vary state to state, any community looking to improve bicycle infrastructure needs to be aware of how these plans may impact the potential liability of the government entity. If a bicycle lane is the permitted area for bicycling, the upkeep of those lanes should reflect the duty of care that is owed to the bicyclists. And we got a question from Ben that I'll just touch on really quickly. He asked if there's been any updates or similar cases, and I am not aware of any updates or similar cases. As I said, this was the Illinois Supreme Court decision, I believe, end of 2023, if I'm not mistaken. So I am not aware of any updates to this.
Yeah, and the one thing I'll reiterate is that, as Katie said, tort immunity laws differ state to state. And one thing that's important about this case is the assessment of the city's duty to the bicyclist owner. So, the court found that there was no evidence of a particular duty since the roadway was not intended for bicyclist use since there was a bike lane. But there are other, it's not just signage and striping that can show that it was intended for a particular use. If there are regulations governing bike lanes versus the use of roadways, if that's evident in your zoning code or other ordinances where bikes can be ridden, that can also bolster a municipality's claim that it was not an intended use of the roadway to limit the municipality or county or whatever regulating body's duty to the bicyclist. Right. So in this case, the Regents of the University of California approved the construction of a new hospital on its campus in San Francisco. A group of property owners residing near the proposed hospital sued to enjoin the construction, claiming that the hospital would exceed local building height and bulk regulations and would be a threatened nuisance per se. So the regents of the university argued that because the university is a state entity, it is immune from complying with local building and zoning regulations when engaging in a governmental activity, such as constructing university buildings. And the court agreed. So the California Constitution establishes the regents of the University of California as a public trust with full powers of organization and government. This unique status allows the regents to have immunity from local regulations unless the state or constitution has expressly waived such immunity. Generally, when the state engages in the construction and maintenance of buildings, it's not subject to local regulations. The court concluded that the regents are exempt from relevant planning and zoning codes because the neighbors did not and could not allege that the construction of the new hospital has no relation to the regents' governmental function of providing education. And I wanted to share, I found this morning. I was doing some work on a similar issue this year, and this is a blast from the past. So this is a Society of Planners update from 1958 about this very issue. And this comes up once in a while. So when state agencies, in Illinois, we have the State Board of Education, we have a bunch of, Illinois Department of Transportation, we have a bunch of state agencies that are very active. And sometimes there comes an issue where local government, a county or municipality, has an interest in regulating a use in a way that conflicts with what the state is hoping to do. But kind of the bottom line usually is that the state, an arm of the state preempts local zoning authority. But as mentioned in the last paragraph here, usually there's no reason for a state to disregard local zoning plans. It's in everyone's best interest to kind of get along especially because the constituents are a common group of people. So just something interesting that I pulled off, I think this was on the APA website, don't quote me on that, but these interesting updates and reminding everyone that what's old is new again in local government law.
So this case involves the regulation of short-term rentals in the city of Chicago. And while it's very much a local case, it probably has application to something similar to your community or to larger cities who often seek to regulate short-term housing rentals. So in Henderson versus the city of Chicago, Henderson was the property owner. He appealed to the Department of Business Affairs and Consumer Protection after he was denied an application for what they call a commissioner's adjustment to allow for 2 additional shared housing units within a multi-unit property that he owned. The city of Chicago's municipal code prohibits registering shared housing units if it's not the host's primary residence. But where a petitioner applies for what they call a commissioner's adjustment, the commissioner can make an exception based on the surrounding circumstances. So Henderson had applied for a commissioner's adjustment, which required him to demonstrate that permitting a shared housing unit would alleviate an extraordinary burden predicated on unique and unusual circumstances. And he originally was given an adjustment to Unit 1 of his property because he was able to cite lost costs and rents that lingered from the COVID-19 pandemic. However, he then went back and what resulted in this case is applied for 2 more units. He thought that after he received the granted adjustment, he would apply for the other 2 and based on the same presentation of evidence, it would be granted. And instead it was denied as to the latter units. So he then sought administrative review, which goes to the circuit court. And the review of that then went up to the appellate court. So he went back and sought an adjustment for the other 2 remaining units in the same property. And he essentially argued the same facts, which didn't put him in a strong place to begin with. The court considered the commissioner's factors for review, which was the number of units in the building subject to the adjustment, the degree the adjustment varies from statutory limitations, and the economic hardship that results of the denial, the welfare of the surrounding property owners, and the evidence that was presented by the applicant himself. The appellate court held that it was within the commissioner's discretion to deny Henderson's application and affirm the decision of the commissioner. And I was curious because they mentioned the address here and it was 1151 West Waveland, which to me sounded like Wrigley, and it is. So I looked it up, and of course it's a block down from Clark and right down the street from Wrigley Field, in case you're curious.
Okay, we have another Illinois case, this one arising from the 3rd District Appellate Court. Neighbors opposed to annexation of parcels versus the city of Joliet. In this case, the appellate court upheld a ruling in favor of the city, finding that a 19.5-foot shared boundary between annexed property and the city met contiguity requirements for the annexation to be lawful. In this case, an owner purchased 3 parcels of land, one of which was connected to the city boundaries via a shared boundary with the plaintiff's property. The 3 parcels were later annexed into the city, and plaintiff filed a lawsuit asking the court to invalidate the annexation because the property was not sufficiently contiguous to the city's boundary as required by law. There was some dispute in the case whether the annexed property abutted the city by 19.5 or 33 feet, but the circuit court held that even if the annexed property only abutted the city by 19.5 feet, that was sufficiently contiguous for the purposes of satisfying the annexation statute. On appeal at the appellate court, the plaintiff argued that the circuit court failed to provide reasoning for its ruling and that the properties were not sufficiently contiguous to the city. First, just sort of procedurally, the appellate court held that it was irrelevant that the trial court failed to provide sufficient reasoning, and more relevant for our purposes, the court held that although there was some dispute as to the nature of the shared boundary, that there is no set law for how long a common boundary must be, and that the 19.5 feet was sufficient to satisfy the contiguity requirement of the annexation statute. The court noted that the boundary was parallel and adjacent to the existing municipal boundaries in a way that courts typically find property to be contiguous. The annexed property was also located in a position that would allow the city to gradually and naturally extend services to the new annexed property, such as fire and police protection, and this also favors annexation. The court also determined that the land was not a strip, corridor, or a cornering annexation that courts typically disfavor. I want to note that the appellate court specifically said it was not adopting a set standard of 19.5 feet for a common boundary in order to satisfy the contiguity requirement for an annexation. And the court said that that determination depends on the individual circumstances and facts of each case. So for Illinois specifically, this case is a good example of what factors courts favor for annexations. So it's not just the common boundary length that they look at, but they also look at the type of land itself. Is it a strip? Is it a corridor? Would it allow for the natural extension of public services? So that's really helpful for our purposes to sort of know and have a good demonstration of what courts are looking for in favor of annexation.
Okay, so this next case, another big issue that we see a lot, group homes and the regulation, legal regulations under the FHA and ADA. So in this case, the District Court for the Northern District of New York dismissed claims that challenged the denial of a special use permit for a boarding home that primarily housed individuals with disabilities. So the boarding house here was mostly used by individuals with disabilities and mental illness in the city of Kingston, New York. Over several years, the boarding house received a series of code violations for fire safety violations, including problems with the building's fire alarm system and the structural integrity of the fire escape. There were various complaints made to the city about overdose activity, police activity, and improper oversight of the property. When the time came for the boarding house to renew its special use permit in 2023, the planning board directed it to submit an engineering report certifying the fire escape's structural soundness. But the boarding house repeatedly failed to do so. After tabling the application and giving the boarding house time for about several months, to get that engineering report in, the planning board ultimately voted to deny the special use permit renewal in July 2023. The denial was primarily based on the fire escape issue, but the planning board also discussed other alleged violations of the property, complaints made by neighbors, and the board members' own public safety concerns with the use. Following the planning board's decision to deny the permit, the boarding house filed a new lawsuit against the city under the Americans with Disabilities Act and the Fair Housing Act. The boarding house alleged claims for intentional discrimination, disparate impact, and the failure to provide a reasonable accommodation, and it sought declaratory and injunctive relief in addition to the award of monetary damages. So the main issue before the court was whether the boarding house could meet the requirements for injunctive relief by showing a likelihood of success on the merits of their claim. The court concluded they would not because they failed to show that discrimination was a motivating factor for the denial of the boarding house's special use permit. While the court acknowledged that some of the public comments at the planning board hearing reflected animus against the residents of the boarding house, none of these comments were made by or could be imputed to the planning board members themselves, who had provided legitimate, non-discriminatory reasons related to fire safety to support the denial of the permit. The court also found that the boarding house plaintiffs failed to establish the likelihood of success on an accommodation claim, since they failed to identify what accommodations they had requested at any time, and the city had refused to make at any time. To the extent that the plaintiffs alleged disparate impact violations under the ADA or FHA, the court dismissed these claims as well because the plaintiffs failed to identify any specific neutral policy that they were challenging or to explain how that policy resulted in disparate impacts to individuals with disabilities as a protected class. For these and other reasons, the court denied the motion for a temporary restraining order and preliminary injunction and dismissed the case.
This is a case from the Minnesota Supreme Court involving the legality of park dedication fees. So an individual purchased an undeveloped parcel of land in the city of Burnsville in 2015 and began the development approval process in 2018. The first phase of the development included an automobile dealership and a bakery. I'm not sure how those go together. And the second phase involved a new building for an auto repair shop. The third involved the creation of an open storage lot. As part of the approval, the city required a park dedication fee, and the original dedication fee was set at $37,000. It was later reduced to just a little over $11,000. The developer objected to the fee, arguing that it was not justified, while the city maintained that the fee was necessary to fund improvements to green space in the regional trail system near the proposed development. The developer challenged the imposition of the fee, arguing that it violated Minnesota statutes governing land dedication for public use as part of subdivision regulations. The district court upheld the fee, finding an essential nexus between the fee and the city's legitimate purpose of funding parkland improvements. However, the Court of Appeals reversed this decision, ruling that the fee was unlawful because the city had not sufficiently demonstrated the need to acquire additional land as required by statute. The Minnesota Supreme Court reviewed the case, analyzing whether the fee met requirements of essential nexus and rough proportionality under Minnesota law, which are taken directly from the Supreme Court case law. And those terms should sound familiar from Aaron's earlier discussion on Sheets versus the County of El Dorado, where the Supreme Court held that legislatively imposed impact fees are subject to the Nolan-Dolan regulatory taking analysis. So the court concluded that the city had met these standards as the fee was based on an individualized assessment of the land's value and the development's impact on public spaces. The court also found that the city reasonably determined it needed 5% of the gross land area of the proposed development to be dedicated for public use in line with its comprehensive plan. As a result, the court reversed the Court of Appeals decision affirming the legality of the park dedication fee imposed by the city.
Okay, the next case I'm going to be discussing is Hatch versus the city of Elmhurst. So we're actually going to go back for this one before we kind of get to more present time. So in 1970, actually, 4 landowners successfully sued the city over zoning regulations that prevented them from building apartments. The decision forced the city to allow the project, subject to certain restrictions, which included prohibiting structures on certain areas of the property unless specified adjoining lots were held by common ownership. The court actually retained jurisdiction over the case to ensure that these restrictions were being enforced. Then, now to 2017, a developer purchased several of those adjoining properties with the intent to construct parking lots. In 2021, the city held several public hearings on the proposed parking lots, and a family that owned the adjoining lot, unrelated to the original landowners from the 1970 case, appeared with their attorney at multiple hearings to object to the plan to build the parking lots. Ultimately, though, the city council passed an ordinance approving the parking lots. In 2023, the family filed a motion to join the 1970 lawsuit and enforce the zoning restrictions against the proposed parking lots. The family claimed that the proposed project violated the zoning restrictions that arose from the 1970s lawsuit. The trial court denied the request and the family appealed. In 2024, the 3rd District Appellate Court of Illinois held, or I should say, they actually overturned the trial court's decision. First, the court noted that the restriction from the 1970s case were still applicable. The court also noted that the court from the 1970s case had expressly retained jurisdiction to enforce the zoning restrictions. And when those conditions were not met, the family whose property was expressly identified in the 1970s lawsuit had a unique property interest that supported their request to join the case and to see that those restrictions were still being enforced. The appellate court rejected the city's argument that the family's challenge was actually to the 2021 zoning approval and that it should have been brought within 90 days of the city's approval of the ordinance under state statute. The appellate court determined that the family was enforcing their rights under the 1970 case rather than challenging the city action concerning the 2021 ordinance. So this is an interesting case, but it just shows that those zoning restrictions will be enforced almost 55 years later, and that the family's unique property interest allowed them to see that those 1970s restrictions were still being enforced.
So my next case, in this case, a company called Molding Investments desired to operate a commercial landfill on property that it owned in Box Elder County in Utah. After the county denied the request for a necessary zoning change to operate the landfill, Molding, the company, sued, alleging that the county had violated its equal protection rights by improperly favoring another proposed landfill within the city. The district court dismissed this complaint for failure to state a claim upon which relief could be granted. On appeal, Molding argued that its equal protection claim was a class of one claim. Molding's complaint alleged that its proposed landfill was similarly situated to the other landfill that had been previously approved. And they were similar because they were both located in Box Elder County, both were publicly opposed based on similar concerns, and both landfills were not situated within a landfill corridor as required by the county ordinance. The court noted, however, that even with these alleged similarities, there were still several key differences between the previous landfill and the one being proposed by Molding. Specifically, while Molding alleged that it was similarly situated to the other landfill, the timing alone indicated otherwise. So the owners of the first landfill had obtained a conditional use permit over a decade before Molding had requested a zoning change. And the other owners had also obtained zoning changes a decade before they denied Molding's other requests, which was government action that ultimately led to Molding's suits. However, while Molding was now suing commissioners for treating it differently than the other landfill had been treated, the earlier decision to grant the other landfill's initial request were made by different elected officials who could have had entirely different political and policy agendas. In the light of the above, the court agreed with the district court's finding that the older landfill and Molding were not similarly situated for a class of one claim. And I just want to note here that equal protection is usually brought by someone or an entity that can show they're part of a protected class, including based on race, disability status, other protected classes under the Constitution. In a class of one claim, it's one entity or person claiming that they're very similarly situated to another group or person, and that they were treated differently on the basis of intentional discrimination. And so the standard for this is very high and very difficult to meet. It's difficult to show you're sufficiently similarly situated to another individual or group to establish that you have an equal protection right. So this was an interesting case involving landfill approvals, and I think it exhibits the class of one theory pretty nicely.
This is our last case in the matter of Gasparini versus the Zoning Board of Appeals for the town of Newburgh. In this case, the New York Appellate Division Second Department affirmed the determination that a two-family dwelling was not a legally pre-existing non-conforming property use. This case involves the Zoning Board of Appeals for the town of Newburgh, New York, which is located in Orange County near Poughkeepsie. I know I did not say that right. The property was located in an area that had previously been zoned for both one and two family dwellings, but the zoning was changed in 1991 to allow for one family dwellings only. The petitioner had acquired the property in 2017. They began renting the top and bottom floors as separate apartments in 2018. Subsequently, in 2019, the petitioner applied to the zoning board seeking either a determination that the two-family use of the property was a lawful non-conforming use, or that grant of a use variance to allow the continued use of its two rental units. The court found that the zoning board's decision denying the request for a non-conforming use determination had a rational basis and was not arbitrary or capricious, since the evidence that was submitted to the zoning board failed to establish that the property was used as a two-family dwelling at the time of the rezoning in 1991. The court also upheld the zoning board's decision not to grant a use variance because the petitioner failed to establish any unnecessary hardship that would warrant a use variance. As the court explained, the petitioner failed to submit dollar and cents evidence showing the property could not yield a reasonable return as a one-family dwelling, and the zoning board also had a rational basis for finding that there was no hardship resulting from the unique characteristics of the property, that the proposed use would alter the character of their neighborhood, and the alleged hardship was self-created. And I think we have maybe 15 minutes for questions.
I think that's appropriate.
Wonderful. Okay. The folks want to talk more about the
Alave case.
Yes.
the Alave case.
No one
And
likes
honestly,
that.
I have questions too. I think this is really, it's an important case and it's an important topic. And I think this could come up at any moment for any number of communities. And I don't even know what else to ask other than, folks have questions. So the first one is a bicycle lane shown on the city of Chicago's plan, either the master plan, transportation plan, a neighborhood plan, whatever, because that, I guess, could impact the negligence of disrepair of the roadway. But then, boy, does that set a precedence, because, we don't want our communities to not include bicycle lanes for fear that everyone is, going to take them to court should they hurt themselves on the road. Thoughts on that question?
Interesting. I think the question about whether or not including something in a plan gives rise to a duty is always something we're cognizant of, and it's odd. One thing that Katie mentioned earlier that I thought was really important is this is an interesting application of tort immunity, negligence, case law, and planning, which we don't see very often. Usually, tort immunity relates to. We see a lot of it with parks and recreational property. We see a lot of it related to slip and falls on the sidewalk that aren't necessarily a planning issue. It's more of a maintenance and upkeep issue. So I think, Bruce, your question is well taken. If a bicycle lane is shown on a plan, does that mean that the city has a duty to keep it in minimum repair, and that would impact I think this case, though, was less about the duty to maintain the bike lane and more about whether or not bikes were an intended use on the roadway that wasn't designated as a bike lane. So just knowing that the difference between the duty to repair and then the assessment of whether or not someone's an intended user of the roadway. There are all these little steps we take in these tort and immunity lawsuits, and we kind of take it piece by piece. And I think that issue is something that's interesting. Katie or Megan, do you have any thoughts on that?
I was just going to add that the case itself does really focus on the legalese, which is the established precedent that has been set by other Illinois courts. And in those cases, like I mentioned, they are looking for affirmative manifestation. So that's signs, pavement markings, anything to really show that the city, like Aaron said, it's the intended user. That's different than permitting someone to use it. It's rather, what did the city intend? So I'm not positive exactly what the relationship would be between a plans versus the city intending it. But at least for the legal side of it, courts are looking at what is around the area. Does it show that the city intended it to be used in this manner?
I know that every time we've talked about this case, and it's mostly amongst Chicago area planners, that it gets a lot of hate, just on the sense that how could you make the argument that you have a divvy bike rack there and you don't intend for people to use the sidewalk next? I mean, just logically, I think it frustrates people.
Could you explain and maybe give a couple examples of you mentioned tort and immunity laws or things. Could you've mentioned it several, you all, I think, have mentioned it a couple times. So for those of us that maybe haven't had land use law since grad school, you could talk a little bit about that and kind of the implications from the planner's perspective on this.
Sure. So this is a big topic in Illinois. Local governments have enjoyed broad tort immunity under a statute in Illinois. So that's why we're saying it varies state to state, is that the reason Illinois municipalities and other units of local government enjoy some immunity from cases, including negligence lawsuits, is because of the statute. But basically, the tort immunity law in Illinois provides a whole range of different actions that local governments are immune from suits for. So one of them that we use a lot is like the enactment or failure to enact some kind of ordinance or resolution. Another one is the failure to grant a building permit. The city is immune from a lawsuit based on that failure to grant a permit. But some of the more traditional ones are, when we're looking at tort immunity, that's one half of the problem, and we get to that eventually. But before the city can claim it's immune from a lawsuit, the plaintiff has to show that the city had a duty. So like I said, there are these little steps we go through in litigating tort cases for cities, whether it's a slip and fall or a bike lane problem. And so in this case, and Katie, you can step in and correct me if you're wrong. I think the court ultimately determined that the case had to stop at that first question of whether the city had a duty, because the thought is that a municipality doesn't have a duty to someone if they're not the intended user of a roadway or sidewalk. So if you're not part of and I know a lot of folks, I've been seeing the comments like, how could you possibly not be an intended user of the roadway? And honestly, I'm surprised by the Olave case because in the past, as people mentioned, there are a lot of cases on riding bikes on the sidewalk, and cities and municipalities almost always win because a bicycle is not an intended use of the sidewalk. Whether or not the inference that a bike lane the bike lane is the only mode of transportation for folks who are riding a bike on the roadway, I think that's a bit of a stretch. Like if you veer out of the bike lane and get in an accident, are you not an intended user? And if I had to guess, even though we haven't seen much development in this over the past year since Olave was decided, I would be surprised if there weren't more and more cases coming, especially with the prevalence of transportation planning, including like multimodal transit and bicycles.
And scooters.
E-scooters, yeah.
There was another question in here, and only because I don't want to spend the whole time talking about Olave, because there was a good Sheets question.
Yes.
I'm trying to scroll to it.
Do
you have it, Christine?
Yeah, I do. Because I pinned it. I may have missed it, but in Sheets, did the county not do a mobility fee study to back up the rates? My take on this case is that it's really important for a jurisdiction to have a well-backed fee study, but that also the impact fee ordinance has an alternative independent study option for those uses that don't fit into the schedule perfectly.
Yeah, so I think one thing to mention about Sheets is that the case was sent back down to the trial court so that it could determine whether or not the fee itself was fair. The court's main holding in Sheets is that whether an impact fee or exaction is imposed by negotiation and contract. So if you have a development agreement and as a condition of development, you ask for a certain sum of money as a traffic impact fee, that's clearly subject to the regulatory takings analysis. In this case, the fee was imposed because the county had passed an ordinance setting forth a table of fees that were applicable to different areas for traffic impact. So I think at the lower level, and if the local district court in California determines whether or not the fee was reasonable, that would be an interesting decision to see come out. But yeah, I think you're right, Cynthia, that it is really important for local governments to have fee studies that are well backed and have good justification and reason for imposing fees the way that they do. I think that's entirely a good reading on Nolan and Dolan so that you can establish that essential nexus and that rough proportionality.
I like the last comment because that I think was the most appalling part of the case. Is this was like supposed to be like a tiny house. It was a container. And yeah, it's $23,000 they wanted in an impact fee.
So I have a very broad question, and I'm going to equate it to like how a bill becomes a law, but only it's going to be how a lawsuit gains traction and gets into a court. And at what point, does a circuit court say, yeah, I'll take this case, or even like a state Supreme Court, like, yeah, like what are the ins and outs of how these lawsuits come to be and like I said, kind of gain traction and the courts choose or don't choose to take it on? How does that work?
So I think the quickest answer to that is the courts that choose are the Supreme Court level, whether the state court or the federal level. Those are the courts that have the ability to take something because enough people, like we mentioned when we talked about the Grants Pass case, we were on hold hoping that the court would take it up because there was so much controversy over not being able to regulate homelessness in parks. And there were, really good arguments on both sides. Was it cruel and unusual? You're giving somebody an ordinance violation ticket for being homeless. So that went up because the Supreme Court felt like they needed to hear it. For your normal cases, that's not how they get there. So, for example, we mentioned a couple cases that were more like administrative type. Even the last one I just talked about, which was something that was a decision made by, I think, a zoning board of appeals. And then the case I talked about that had to do with the property owner near Wrigleyville. Those were more like commission-like cases. So when then they get appealed, their first appellate level is the trial court, like circuit court. Most cases, though, start in circuit court, and then someone has to appeal it to get to the appellate level. And then if the appellate court declines or differs from that, then it can go up to the Supreme Court. But it doesn't always work that way. So I don't know that I gave you a very good answer. Jump in, Aaron and Katie.
Yeah, I mean, it's complicated. Civil procedure is, I think everyone's least favorite class in law school for the most part.
Yes.
But yeah, Megan's right that the trial court level, they don't really have discretion to not accept a case. I mean, there are a lot of cases get thrown out at really early stages, like a motion to dismiss stage or a motion for summary judgment. So, or they're settled. So I think when I was in school, it was something like over 80% of civil cases are settled. Not a lot of cases go to trial anymore. So that's why we pay attention to these cases that ultimately do get raised to higher and higher levels, because it's so uncommon for these issues. But like Megan said, we're always watching out. And even Olave, which went to the Illinois Supreme Court, that case is going to be binding on the lower courts for years until the Supreme Court changes its mind potentially and has a different assessment of what the intended use of the roadway is.
I think the de Villiers case is a good example sort of how a case can get thrown out, sort of, I would say somewhat based on standing, where it's pay first, litigate after. someone needs to actually pay the fee that they're challenging to have standing to litigate that fee. So that's another important thing to note too, is whether the person actually can bring the lawsuit. Sometimes the courts will just throw it out because you weren't impacted by it. So that's something to consider too, of who can actually file the lawsuit.
That's a good point, Katie. Actually, the Sheets case that bothers people, that it was a $23,000 impact fee for the container-like house. They were forced to pay that impact fee before they could even appeal at the very first court, which seems so fundamentally unfair.
If they do get it back, do they get it back with like interest or anything, or is it just you get it back?
Ugh.
That's a great
Don't
point.
know.
Yeah, I think it depends.
I don't know. That'd be my first question.
I know, right?
Yeah, I think California has an interesting rule. Katie mentioned it right at the top of the presentation, the pay before you litigate rule. And I don't know if that's universal, but it's a little crazy. Like you have to pay under protest and then file a lawsuit. I don't have $23,000 lying around, certainly, to pay a permit fee before I also pay lawyers to litigate. So that's hard.
Phew. Real quick, one more question. Is there any update on the Grants Pass v. Johnson? And have there been any similar cases developing since then?
That was a Supreme Court case. So I guess the questions are, the litigation trickled down to overrule anything?
Yes. Yeah.
Which I would expect that it will. I personally don't know. I don't know if you guys do. That case, the Boise, Idaho case, I think that's the case I talked about, where if there was room at the shelter, but you weren't staying there and you were charged with a crime, that case would be reversed, since that had stopped the ability of local governments to enforce that. But I don't know. I haven't heard. This decision, it just came out a couple months ago, which is fairly new in our
fresh.
world.
Yeah.
And it was really long.
Yeah, now our deal is policy making has become complicated because of Grants Pass. So we're dealing with the aftermath on that side of it, is like, how do we regulate this activity under the decision in Grants Pass?
You mentioned a case law reference website at the beginning of the webinar. Could you post the link or tell us, or put it in the chat and I can get it? Do we know what we're talking about?
I think so. So I mentioned AnselsGlink.com has a resource link, and
that's what I was assuming you were.
Yeah, and also our blog post, which is the top of our website under blogs. But there was a specific case law update that I think would be great for the planning community, called the APA CMS bar exam. And I know it's under our resources because I saw it earlier today. And that's a bunch of cases that we hit on right before the AICP last test.
Okay.
Oh, perfect. Thank you, Christine, for sending that.
On it. There's a lot of good stuff under there. So
there is.
It's free. So
yeah,
take advantage.
Be sure to take a peek. I just put it in the chat, everybody. All right. We got to wrap up. It is time to go. Thank you for joining us again this year. This was great. And I feel like I leave the sessions with you and my brain is really full. But I guess it's supposed to be that way. So thank you. This was wonderful. Again, folks, we are recording this session. We'll have it up on our YouTube channel on Monday. Don't forget to log those CM credits. If you also head over to our website, ohioplanning.org/planning webcast, don't forget to sign up for our email list, and you'll get one email a month from me letting you know about upcoming sessions. So thanks again. Thanks to our friends from Ansel Glink and to the Illinois chapter of APA. Everyone, have a great weekend, and we'll talk next time. Thanks, everybody.
Thank you.
Happy holidays.
Wow, what an excellent webcast. Thank you to the Ohio chapter of the APA for having us, for the APA Illinois state section, or Illinois chapter for also inviting us there, and not to mention Megan Mack, Aaron Monforti, and Katie Nagy, an excellent summary of important planning law cases to know. Which brings us to the Department of Public Works on March 13th. Megan Mack, the very same, Greg Jones and I will be hosting the 10th annual APA CMS bar exam at a brewery in Oak Park. It is a new location this year, One Lake Brewing in Oak Park, in a historic building, which planners will love. And it's another opportunity to get updates on important planning law cases in a fun environment. It's my favorite session every year, and we'll be recording it live for Ansel Glink's Quorum Forum podcast. But you can attend live, a live podcast recording. I can't think of anything more exciting. And of course, the APA Illinois State Section Conference is April 24th and 25th. I heard you can use promo code Forum Fans, all one word, just for Ansel Glink Forum podcast listeners, to get $5 off your conference registration. How cool is that? Before we go, I want to remind everyone to subscribe and leave us a review wherever podcasts are heard. We prefer good reviews. Email us your questions and show ideas at podcast@anselglink.com. And as always, you can visit us online at quorumforum.anselglink.com. Can I get a motion to adjourn? So moved. Second. All in favor. The ayes have it. We'll see you next time at Ansel Glink's Quorum Forum podcast. Bye.